Okay, Mr. Chairman, we are ready.
Okay. Good evening, everyone, and welcome. The March 9th, 2021 Liquor Board meeting hearing is now in session. We normally, first order of business is approve the minutes of our February 23rd meeting. Unfortunately, they're not available and will be available at our next meeting for approval. So at this time, I'd like to turn the meeting over to our counsel, Phil Dales.
Thank you, Mr. Chairman. I am Phil Dales, co-counsel to the board, and at this meeting, I want to take a minute to say it's been my pleasure to help the board and serve as co-counsel with Harry Blumenthal when he was still alive, and then after Harry's passing to help transition this board to its new full-time counsel, Mr. Jimmy Fraley, who's on the call this evening. And with that, I'll read our regular statement that we read at the beginning of every meeting, which is that the commissioners are part-time public servants. They have other outside interests besides this commission. They are known to have, when they know that they have a conflict of interest or the appearance of a conflict of interest, they recuse themselves. However, they cannot possibly know who will appear from the public in any matter which may present a conflict of interest to them. If anybody believes that a commissioner has a conflict of interest, you have to let us know that when the case is called or prior to the case being called, so the commissioners can deal with it accordingly. If no one says anything, the commissioners will proceed with all hearings under the supposition that there is no conflict of interest. Second, the rules of the board provide that the chair, for purposes of administrative and judicial economy, can have the board's counsel, which is me and Mr. Fraley, rule on admissibility of evidence and objections if there are counsel present and objections made. The board handles a multiplicity of cases at every hearing, and this assignment allows us to expedite the hearing. So instead of the chairman turning to me and I advising the chairman, I or Mr. Fraley will simply make a ruling, and our ruling will be the ruling of the chair. Last, this is a COVID-19 hearing. Our rules are published online and anyone can read them. The public can participate, but only by written statements presented to the board prior to the meeting. Commissioners have read all applications, exhibits submitted with the applications, including floor plans and other documentation, and all statements submitted by the public in testimony. The public is invited to listen and look at our hearings, and there will be no personal participation by live video testimony from the public. With that, I'll turn the matter back to our chief inspector, who will call it the first case. Actually, one other comment. During this time of year, the board customarily renews its licenses. So during the renewal period, it's the board's custom not to issue new or transfer licenses until after May 1st. That's because we're not able to quickly turn around a renewal after that issuance. And the board staff is very busy renewing all the licenses. And so applications for new or transfer licenses to be issued before May needed to come in before the end of February. So thank you very much. And with that, I will turn the meeting back to the chair.
Thank you, Mr. Dales. Wayne Harris, Chief Inspector for the Anne Arundel County Liquor Board. Our first case is Klaus Liquors, known as ISH LLC. Harish Patel, President, Secretary, and Treasurer. James Phillips, Clerk. Marcia Smith, Barmaid. Chief Inspector Wayne B. Harris, Sr., and Inspector Earl W. Barnes. This is a Class D license for beer, wine, and liquor, and has entertainment and Sunday license. Located at 604 Crane Highway North in Glen Burnie, Maryland, 21061. Violations are as follows. Violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.05, Sanitation and Safety. Reference the Board of License Commissioners for Anne Arundel County violation notice number 2271 dated December 14th, 2020. Second violation is violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County. Chapter 3, Section 3.09, Public Welfare. Reference Board of License Commissioners for Anne Arundel County, violation notice 2271 dated December 14th, 2020. The third violation is violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.16, illegal conduct. Reference Board of License Commissioners for Anne Arundel County, violation number 2271, dated December 14th, 2020. There's other violations for a second case, and same establishment, violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.05, sanitation and safety, reference the Board of License Commissioners for Anne Arundel County. Violation notice 2270 dated December 11, 2020. Violation number 5 is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.09, public welfare, reference Board of License Commissioners for Anne Arundel County, violation number 2270 dated December 11th, 2020. Violation number 6 is violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 3, Section 3.11, sales and consumption adjacent to premises. Reference the Board of License Commissioners for Anne Arundel County, violation notice 2270, dated December 11th, 2020. Final violation is violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.16, illegal conduct, reference Board of License Commissioners for Anne Arundel County, violation notice number 2270 dated December 11th, 2020. This is a Class D license for beer, wine, and liquor, entertainment, and Sunday, 604 Crane Highway, Glen Burnie, Maryland. And with that, I'm going to ask anyone wishing to testify for or against to please come forward. Raise your right hand. Our administrator, Edward Aronson, will administer the oath.
Raise your hand.
You're muted, Mr. Aronson.
Thank you. Do you solemnly declare and affirm under the penalty of perjury, the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do. Thank you.
My name is Wayne Harris. I'm the Chief Inspector for the Anne Arundel County Liquor Board, located at 2660 Riva Road, Annapolis, Maryland, 21401.
Chief Harris, would you read the case?
Yes, we have other sworn personnel.
Done swearing everybody in?
Yeah, everybody's sworn in. They have to identify themselves by name and address, though, Mr. Dale.
Who do we still have?
Mr. Barnes or Inspector Barnes.
Okay. Earl, you're muted.
Muted.
Okay, unmute. Okay, can you hear me now?
Yes, sir.
Okay. Earl W. Barnes, Inspector, Anne Arundel County, 2660 Riva Road.
Thank you. Mr. Mays, do you have people testifying? You may want to have them state their name and address for the record, please.
Yes, sir. First off, Michael May, MAY, on behalf of the licensee, and I have co-counsel who I think ought to identify themselves for the record, please.
My name is Ed Hartman, Hartman, and after the identification of the witnesses, if you don't mind, I would like to make a preliminary request because it is procedural in nature and should be at least presented prior to the testimony of any witnesses. But I'll certainly allow Mr. May to identify the witnesses first.
Christian, go ahead.
And Christian Hartman, Hartman, also on behalf of the respondents.
Miss, state your name and address, please.
Marcia Smith, address is 8051 Solly Road, Glen Burnie, Maryland, 21060.
Thank you. James.
James Phillips, 3525 Joanne Drive, Baltimore County.
Thank you. Rush.
My name is Parash Patel, 2413 Pebblebrook Court, Davidsonville, Maryland, 21035.
Thank you. I will turn it back to the board or to Mr. Hartman.
Thank you very much, and appreciate the opportunity to speak on this rather unusual forum. Hopefully one day we get to see one another again. My objection to this proceeding is fairly brief, but as you may or may not know, I've been, over the past 4 months, I have been crossing the state litigating executive orders and COVID issues, including jurisdictional ones. And it is very clear to me and has been decided in other courts, although nothing precedential by the Court of Special Appeals, but Governor Hogan's executive order dated April 5th of 2020 delegates specifically to the county health officer and only to the county health officer the authority to bring citations and violations of the governor's and the county's executives' orders pertaining to violations of COVID. Those orders, all of the executive orders also suspend any state, county, or other rule, statute, or regulation or agency guideline that is inconsistent with that grant of authority. Meaning essentially that no matter, regardless of what the county code might say or the rules and regulations might say, that the only person who has the ability to bring a violation for citation or citation for a violation of the COVID-19 rules as established in the governor's order and the county executive orders is in fact the county health officer. In this instance, that would be Dr. Kalyana Raman. I recently defended a case in St. Mary's County, which was brought by the county health officer and defended, actually prosecuted by the Attorney General's office out of Baltimore. And that was determined in that case that that was the proper procedure for bringing such a violation. So these charging documents, such as they are, identify violations of restrictions that are specifically in place as a result of the governor's and the county executive's orders as a result of COVID-19. Otherwise, these would not be violations. Accordingly, I would request that this body at this time dismiss this citation, recognizing that it does not have jurisdiction. Consistent with this problem is the fact that imagine whatever findings of fact this particular body might make tonight would then have to be brought again and determined again in different courts or different agencies if each individual agency were entitled to bring an action for violation of the executive orders, including the court, including a criminal court, because there are in fact criminal citations which can be brought as a result of the alleged violations of the COVID orders, which include potential incarceration and fines, and giving rise to procedural and substantive due process issues that would be affected dramatically by this particular proceeding, where evidence will be taken, witnesses are sworn, and findings of fact will be made, and rulings of law will be entered, all to be perhaps tried all over again in various other jurisdictions who are specifically identified as the correct ones. So I respectfully request, I understand you're doing your job and doing it very well, but I respectfully request that this particular board, the Alcoholic Beverage Control Board for the Anne Arundel County, does not have the authority or the subject matter jurisdiction to hear violations of governors or county executive orders related to the COVID-19. Thank you.
So I have a couple of questions for you about that. Mr. Presley, do you want me to go or do you want to ask any questions since you're?
Go right ahead, Mr. Dales, and if I have anything else, I can follow up.
Mr. Hartman, I think these are very interesting arguments, and of course, if the board chooses to enforce the violations tonight, we have the opportunity to petition for judicial review in the circuit court and raise all these interesting arguments and brief and argue them to the circuit court. I would ask, do you think that the violations in this case are not violations of the board's rules cited in the citations?
Well, to the extent that the board rules are very broad and include also actions that are specifically identified as violations of the executive order, then you have arguable concurrent jurisdiction, but because the executive orders specifically exclude other statutes and rules and regulations, to the extent that there are violations of, or even alleged violations of rules pertaining to COVID-19 and the governor's and county executive orders, then this board cannot proceed. And I think that the simple way to think about it is, imagine if next week the state's attorney's office decided to bring charges against some of these individuals, which they're authorized to do. So what position does that put these people in tonight as far as testifying? Because now whatever testimony there had could be, although not yet because there are no criminal charges brought, but we won't know. So how is it possible that they can respond and defend themselves in this instance, given that situation, which is exactly why those are set forth in that order. Can only be one proceeding for the violation of the executive orders.
That's an interesting argument, and I appreciate the answer, because that was what I was asking, was whether you thought the jurisdiction was exclusive in this case and these types of violations. And I think that's a good answer. However, early in the pandemic, this board addressed the possible concerns of the authority of its officers to issue citations and enforce executive orders, and determined that the executive orders did provide us the authority, along with the county charter and the governor's executive orders. And so my advice, and I believe this is shared with co-counsel, is for the board to hear the violations and make decisions with the ruling being implicit on this preliminary matter, that we do feel we have jurisdiction. And then, as I said at the beginning, if you choose to petition for judicial review, those issues can be briefed and raised again in circuit court.
Understood.
Did you have anything to add?
I would just respectfully request an actual ruling from the board on my motion or request. I realize it's a fait accompli at this point, but I would ask that there be a formal ruling so that I would have something to judge if I sought declaratory and injunctive relief tomorrow or at some other time.
Mr. Braley, do you want to make a ruling, or should we just advise the chair and let the chair debate and consider the ruling? I don't know.
I think it's appropriate to advise the chair and have the chair consider the ruling.
So, Mr. Chairman, you heard my view on how we should handle the legal argument here. And so Mr. Hartman's asking you to make a ruling on the preliminary motion. I think that's proper. So you and the commissioner should consider the legal advice that we've discussed earlier, and then make a ruling, and then let us proceed unless you're going to grant the motion to dismiss. Mr. Chairman, I think you're still on mute.
Mr. Maloney, you're muted, sir.
Okay, excuse me. Sorry. Yeah, I'm going to go ahead and move ahead with our hearing. Not sure exactly what the proper.
I think the proper rule, the motion should be a motion to deny the.
Okay, would be
deny Mr. Hartman's motion. You can have the commissioners vote on, or you can just rule. I'd say you should have commissioners vote.
I will deny his motion and ask for a second.
This is Commissioner Duffy. I'll second the motion to dismiss.
Any discussion further? All those in favor say aye.
Aye.
Aye. Aye, it's carried. Thank you.
And I think then procedurally now we go to Chief Harris to read the report that I asked for far too early.
Okay, thank you, Mr. Dales. Wayne Harris, Chief Inspector, Anne Arundel County Liquor Board. This is for the first violation being heard tonight.
Excuse me, Chief Inspector. Mr. Dales, I have another argument to make as far as the charging documents. So before he goes into the facts of the case, I have an argument to make as far as the charging documents being defective. This is Michael May for the record.
Yeah, with our typical procedure, we're accustomed at the board, you'll have the opportunity to do that after the chief reads the case, and you'll have the opportunity to question him. But you can make arguments regarding the charging documents when you're presenting your case, Chief.
Okay.
Go ahead, Chief Harris.
All right, again, Chief Wayne Harris. Report reads as follows. On 12/11/2020, this inspector was driving by the north end of Klaus Liquors located at the above address, which is 604 Crane Highway, Glen Burnie, Maryland, and noticed a group of gathering at the outside on the sidewalk. I noticed several people had drinks in their hands and some were consuming same. This establishment is well known to this chief inspector, as I have visited Klaus Liquor both by myself and also with the regular assigned inspector, Inspector Earl Barnes. In late September, they were cited for several COVID-19 violations and voluntarily paid a first offense fine. It was also in conversation with the Northern Police Department in reference to assisting them in setting up a meeting with the licensee, Mr. Patel. That meeting did take place, but I wasn't involved in the meeting. The licensee was to discuss previous incidents and the illegal gathering of people outside the rear side door of the sidewalk. This is
now, excuse me, I'm going to have to object. He's bringing up situations that existed prior to this incident. We're here for the 11th and for the 14th. We're not
Overruled,
here.
Mr. May. We're gonna hear the report.
Okay,
Go ahead, Chief Harris.
thank you. This establishment does not have an outside privilege by the liquor board, nor an acceptable designated area for outside service covered by the governor's proclamation, period. I entered the front door of the establishment at about 5:11 p.m. and met with Mr. Paresh Patel, the licensee and operator of Klaus Liquors. I explained what I observed outside and asked him to follow me outside to disperse the patrons hanging around. We exited the rear side door and I pointed out 3 individuals who are holding and/or consuming drinks, which I believe come from inside the bar area of that establishment. Mr. Patel informed me that he had to stop hanging around, that they had to stop hanging around the outside of the establishment and must go inside or get rid of their drinks. We then entered the rear side door into the bar area where I noticed the size of the crowd, which included at least 3 people standing with drinks in their hands, which is a COVID violation. The size of the group in the bar area exceeded the 25% of the capacity mandated at that time. And that capacity for that establishment is designated by a sign hanging on the wall of 25. According to the fire marshal capacity sign posted on the wall. The crowd was much larger than the 6 or 7 that was permitted. And there were approximately 9 people in the bar, plus 2 or 3 who were walking around between the retail portion of the establishment. And that did not count the subjects who were outside that re-entered at our request. This inspector explained that the violations and the seriousness of the offenses, and Mr. Patel was upset by the occurrence, and I explained that I would return at later and on to check for further compliance. I was not able to issue a written citation at that time due to the fact that I didn't have my citation or violation book with me. This inspector returned on December 14th at about 4:50 p.m. To issue a copy of the written violation notice, and the violation notice was presented to the sales clerk at that time, Mr. James Phillips, to sign, but and make sure that a copy was given to Mr. Patel when he returned the next day. Mr. Phillips agreed, and when asked whether he was on the management agreement or not, he was unsure. This inspector said I would follow up on that issue at a later time, which I have. Violation notice 2270 was issued on December 14, 2020 for the following, and that's as read: 3.05 sanitation and safety, 3.09 public welfare, and 4.16 illegal conduct, and then also 3.11 sales and consumption adjacent to premises, which is not a COVID-19 violation. That's the end of my report dated December 11th, 2020.
Thank you, Chief Harris. Chief, you also have knowledge of the COVID policies, COVID enforcement policies for all the various rules related to the executive order, is that correct?
Yes, that is correct.
Just wanted to put that on the record as we've done in the past, so that the chair, commissioners may ask you questions about the incident. So do the licensees or the attorneys for the licensees have any questions for Chief Harris? Mr. May?
Yes. As far as the 11th, that's when you indicated that you had people outside?
I observed people outside. Yes.
You said you believe that they may have had drinks from there, but you're not sure.
No, I didn't say that. I said I observed 3 or 4 with drinks in their hands.
3 or 4?
3 or 4 people. They were moving around, Mr. May, a little bit. So the best I could tell was a minimum of 3 and possibly 4.
What did you see in their hands?
Mixed drinks, cups.
Did you ask what they were drinking?
No, I did not.
I went in to see Mr. Patel and asked him to accompany me outside.
So you don't actually know what was in the cups?
True. But the violation is, whether it be Coke or an alcoholic beverage, would be a violation of those COVID-19 rules. Any consumption of liquid or food while standing is a violation.
And which regulation specifically, which order are you, I think Mr. Dale's asked you what, you're familiar with the rules and regulations. What specific executive order are you referring to?
I'd have to go back and research the one that was in effect on December 11th, but I believe it might have been Executive Order 40 or 41 or 39. Again, I'm not positive, but I can tell you that. It was the one that was in effect on December 11th, 2020.
Now you indicated the fire department sign had a 25 person. That's not for the establishment in total, is it?
That was the only capacity sign that was apparent and properly displayed in the establishment when I went in there, and that was behind the retail portion of the establishment where packaged goods are sold.
And that indicated, and you're saying that that was in the retail part of the establishment?
It was about the center of the establishment. I guess if I was to measure it, I'd say it was approximately the center, located between the retail portion and the bar portion. And that's an open area. So it's not separated by a door or doorway, it's open.
I don't have any other questions of Commissioner, or I'm sorry, Chief Inspector Harris at this point.
Thank you.
Thank you, Mr. May. Now, Mr. Chairman, do you or other commissioners have questions of Chief Harris? Mr. Chairman, unmute.
This is the chairman, and I have no questions.
Commissioners Duffy and Pilkins?
This is Commissioner Duffy. I have one question for Chief Harris. I know Mr. May asked if Chief Harris asked the question of the patrons, if what they were drinking in the cup. But I want to ask Chief Harris if Mr. Patel asked the individuals themselves, his patrons, what was in the cup. And you can say yes or no to that.
We did go out and he didn't even bother to ask them. He just told them they had to either come in with the drinks and sit down or pour out their drinks and leave.
Okay, thank you.
You're welcome.
I have no other question.
Commissioner Pilkins?
No, I have Commissioner Pilkins has no questions at this point.
All right. So, Mr. May, you can now present your case, including your preliminary issues regarding the documents for the violation. You're on mute, Mr. May.
Well, saying thank you, and I was still muted. So thank you. As far as the preliminary motions to these charging documents on the 11th, the process requires, due process requires that you be notified of what you're charged with. And what I'm suggesting and making a motion that these charging documents are insufficient. Even when you pair them with the report that Chief Harris just referred to, you still have to be able to line up with what the violations are and what the offenses might be. When you hand somebody a citation, such as and the commission has seen them, they all know what they are. They're just a single little thing that has numbers on them. Thank you. They've got 3.05, 3.09, 3.11, and they just say sanitation, safety, public welfare, and sales and consumption. Then the other one has to do with COVID, which is other, which is listed at 4.16. The specificity of these charging documents is insufficient to let the person bring forth a defense to these charges. They're too overly broad, and they deny the due process. This board has the authority to take a license away based on these charges. And being the board has taken and made the determination that the executive orders are valid or are going to be enforced, then you have to follow through with that. And the rest of it is having to do with that the Anne Arundel County may, under alcoholic beverage annotated code section 11-206, Anne Arundel County may employ who inspectors who, pursuant to the Maryland Alcoholic Beverage Code annotated 11-2605, may issue a civil citation provided in Maryland criminal law annotated section 10-113. Maryland criminal law 10-119D2 lays out specific requirements as to forming contents, requiring certain things be in those citations. These citations don't have those documents or don't have those things in them. Specifically, they don't have location, they don't have time, they don't have the fines that may be imposed. Additionally, you are putting Chief Harris in the position of, basically, because of the arguments that were made by Mr. Hartman earlier, in the position of issuing what are essentially criminal citations, which I would suggest to the commission he does not have the authority to do. And it also, based on the Maryland Annotated Code, the alcoholic beverages 3-60282 and 11-206 empowers the board as far as the inspectors and what they can do and what they can't do. And it indicates that in this particular citation that, and I'm bringing this up now because the board's going to be considering it shortly, that there actually become criminal citations under these executive orders and the way the annotated code is written as far as alcoholic beverages are concerned. And with that in mind, it's not simply, the burden of proof is not, it's beyond a reasonable doubt, because they've now become criminal citations because you can be incarcerated for violating any of them, which is what this board has already made a determination earlier this evening that they have to do. So based on the due process and vagueness, I'm making the argument and the motion that these petitions do not adequately, or these charges do not adequately provide the licensee with the ability to properly defend according to the due process that they're entitled to under all the laws and regulations of the state Constitution, Declaration of Rights of Maryland, and the Constitution of the United States.
Okay, so Mr. May, I'll let you choose. Would you like us to rule on an actual motion here, or would you want to proceed with your case?
I would prefer the motion be ruled on as the deficiency of the charging documents first.
So, Mr. Chairman, commissioners, you heard two arguments there about the charging documents. The first one, I don't think it requires too much explanation. It's with regard to the specificity of the charges on the documents. I think you'll have a question for yourself, to ask yourselves in reviewing those documents as to whether you think the charges are sufficiently specific there. And now I'll move to the next issue that Mr. May has raised the due process issue and respectfully disagree with Mr. May on the due process issues and the interpretations that he's raised. I'm advising the chair that I don't find a due process concern from the interpretation of the code that he's provided. But you can ask questions if you want to explore that further, and I'll do my best to answer them. And then with that, I think we can discuss and rule on his motion on both grounds.
Okay. Well, with regard to the charges being specific, I would tend to look at as you mentioned, Mr. May, the violation notice, where we cited citation, public welfare, sales consumption, and followed up with a statement that the inspector wrote out. So, I mean, it's, I think, more of a simplified, it's more simple than it appears to be, that there were some violations with regard to what was going on at that establishment. And in addition to that, with regard to due process, I'm thinking that this is what we do. And we're, for the most part, fair. For the most part, we're relying on what our inspectors do. And I'd question whether or not there's a problem with due process.
Mr. Chairman, I'd like to add 2 points to my earlier advice for clarity. I wouldn't agree that citation from the board rise to the level of criminal charges because of the interpretation Mr. May has explained. And then I also want to remind everyone that this is an administrative agency. And so our decisions with regard to whatever our decision is, if there's a petition for review, the court's going to look at these issues of law de novo. You know, they'll give some deference to our decisions about what the facts are. But these issues about the legal interpretations can be raised again, and you know, our ruling here does not affect the court's ruling. So you can make your own ruling and then let Mr. May raise the appeal to us. So I think you know, a motion is in order unless there's going to be discussion.
In what regard?
Motion to deny or grant the motion to dismiss.
Oh, we would deny his motion to dismiss.
Commissioner Pilkins seconds that.
And all those in favor? Aye.
Aye.
Carried.
All right, Mr. May.
Mr. Duffy was muted, I think.
Mr. Duffy, you're muted, sir.
We didn't hear your vote.
Mr. Duffy, were you?
Yes, I did state aye. Thank you for bringing that to my attention.
Sure.
Mr. May.
Could I have Mr. Aronson in Mr. Dales and I had discussions about how to present evidence in these difficult times. So it was requested, and I supplied certain things to Mr. Aronson, who has the ability, I believe, to pull certain items up. And I just got to get the correct number for him to do that. Mr. Aronson, if you could pull up the fire department, it's listed on the sheet that I sent to Mr. Dale's fire department.
The image?
Yes, yes, please.
Okay.
We'll just ask the board members to look at that, and you can see that it indicates bar room and not the entire establishment. So in the process of these arguments, I would ask the board to keep that in mind.
I'm sorry. Is,
Can
Mr. Chair,
everybody do that?
I couldn't read that, so I'm sorry about that, but
Mr. Aronson, if you bring that up again, I think it's the lower left corner is, I think, Mr. May, correct me if I'm restating this wrong, but you're referring to the licensed premises being the bar room.
Yes, sir.
That's your argument.
Oh, it's not the occupancy? Okay.
so the occupancy in the bar room is 25? Is that what that's saying?
Yes,
Okay.
well, at least that's my interpretation.
Mr. May, which one? That was the fire department image. Was that not the right one?
Yes, no, that was correct.
Oh,
Mr. May, could you clarify your argument there? Because I think we had some questions that were sort of out of order about what you're trying to show us.
I'm just trying to show you that contrary, and this is just part of the case, and I mean, I'm doing more as far as the case is concerned. Chief Inspector Harris was indicating that this was actually for the entire establishment in his testimony. And I'm suggesting it's not for the entire establishment, it's for the bar room. And that's why it says bar room and not for the entire establishment located at 604 North Crane Highway. Right there, thank you.
Or Commissioner Pilkins doesn't understand that. I don't think that the chief inspector was talking about a 25, the number 25. I think it was a larger number and it was in the center of the building. So I'm just trying to keep this straight, but I'm confused at this point. How this works in to your case, Mr. May.
Well, how it works in, Commissioner Pilkins, is that there is only one sign in that establishment. Commissioner Harris, or Inspector Harris, Chief Inspector Harris, I'm suggesting was incorrect in what he was talking about, because there is no other fire department sign other than that one, and that's in the bar. And I will have testimony to that effect. So.
Well,
so I don't know if that answers your question, Commissioner Pilkins.
No, it's left me confused. It's just that the number itself is so small that they could only have 4 persons in the entire place and they'd be over the 25%. So I don't understand. That's what has me confused, how that helps your case, Mr. May. I just want to be sure I understand it, that's all.
Because when Deputy Inspector Harris was testifying, he was testifying as to 9, I believe he said 8 or 9 people within the establishment. And that's not within the establishment. And look, the burden's on the board or on the commission here. It's not for the licensee to have to prove his innocence. The commission, through Chief Inspector Harris, has brought these charges and they have the burden of proof. And based on, and I know Mr. Dales has already disagreed with what my analysis as far as the burden of proof is. I'm just raising these things so that the commission can make an informed decision as to all the charges when the time comes.
That's fine. I'll be quiet now and listen to the rest of your case.
Well, on that note, Commissioner Pilkins and Mr. Chairman, we see that Mr. Inspector Barnes has his hand up, and I just want to clarify whether you're looking for me to ask Mr. Barnes to speak, or Mr. Chairman, I think if you want to hear that, then you should feel that you can ask that question. But I want to point out that his hand is up, and I'm leaving it to you to call on him to ask if you want.
if he has something to add, certainly.
Well, okay. I'm going to object. This is my case, Commissioner Barnes. I haven't called Commissioner Barnes to testify. If the board wants
we're not in circuit court. So, then, Mr. Chairman.
Yeah.
May I speak or not?
Go ahead.
Yes.
Okay. That sign has never been in that bar, in the back part of that bar. It has always been up front. He has a complete board up next to his. As you walk in there, you have a counter to your left and all his items. Then you have a cool box. That sign, that 25 capacity sign, is on that board with the rest of his paperwork. It has never been in that bar in the back. As a matter of fact, I'll be honest with you, that's the first time I ever noticed that it actually said bar room on there. And 25 would probably be the limit you could put back there. It's a very small bar.
Okay, thank you.
Okay, thank you, sir.
Mr. May.
Indulgence, please. Based on what has been presented, I am not going to present any further evidence as far as the violations on that we're dealing with at this point in time.
Okay. Is that the conclusion of all of your presentation of testimony and proffer?
We're still dealing with only the 11th?
Chief Harris, can you confirm that that's what all we read, the charges?
Yes, Mr. May, Mr. Dales, that report that I read only deals with the 11th. We still have, and that was 4 charges. On that, we still have the other 3 charges that are dated 12/14, 3 days later. And I can read that whenever you're ready. Or
that's a yes, Mr. May. But that's all. So if that's it, then I think where we go now is to allow the chairman and the commissioners to ask questions of Mr. May regarding his argument.
Yeah, this is the chairman. I have no questions.
Commissioner Duffy Pilkins?
Commissioner Pilkins has no questions at this point.
Commissioner Duffy, I have no questions at this point.
Okay, so Mr. Chairman, do you prefer that we go to deliberation and decision on this charge, or do you want to move to the next case and then do all the deliberation and decisions together?
What would you recommend?
I don't have a preference, I think.
All right, why don't we just...
Do you have a preference?
Let's move on and just hear the rest of them, and we'll make a determination.
Chief Harris?
thank you. Wayne Harris, Chief Inspector, Anne Arundel County Liquor Board. This is in reference to the 3 violations on a report dated 12/14/2020 at Klaus Liquor, 604 Crane Highway, Glen Burnie, Maryland. The report reads as follows. On 12/14/2020, this inspector went to the above establishment in order to get a violation notice signed. When I arrived, I found the retail clerk, later identified as Mr. James Phillips, behind the packaged goods counter. I identified myself and asked if Mr. Patel was there, and he said no, he did not expect him until the next day. Mr. Phillips then waited on a customer, and I walked back to the bar area located in the rear of the building. As I approached the bar area, I noticed the barmaid, later identified as Marcia Smith, standing at the closest end of the bar, speaking with an unidentified male who was conversing with her with a drink in his right hand. Neither had masks on in place and covering either their mouth or their nose or mouth. I identified myself and requested both to pull their mask up, which were below their chins. Ms. Smith then said that she was in the process of eating and showed me a container of food, which was sitting on the bar. It was a small cup style. Let's see, and I noticed it wasn't even open as of that time. I did inform her that she could remove the mask to eat, but not while speaking to any other person, and that she had to be safe distance between them. At that time, I saw these 2 subjects. They did not have any masks, but were located within 2 feet of each other. They were relatively close. A COVID violation as well. As you know, the safe distancing is a minimum of 6 feet. I noticed there were only 4 bar stools, of which 3 were empty at that time. I informed the male customer he had to be seated while he was consuming his drink, which would have been, of course, another violation, standing and drinking. He agreed to do so and did. I returned to the retail clerk and informed him of what I saw and proceeded to issue a violation notice for the violations observed on that date. Mr. Phillips agreed to sign the violation and make sure the licensee, Mr. P. Patel, received a copy. The violation notice 2271 was issued for 3.05 sanitation and safety, 3.09 public welfare, 4.16 illegal conduct. It should be noted that after checking on an active management agreement, Mr. James Phillips, none was found. Therefore, the establishment was left unattended with no supervisor who was either on an active management agreement or had an alcohol awareness training certificate as required by state law. No violation for this was issued at that time. And just so I know, just so you know, I have informed Mr. Patel personally on several occasions about that. And I believe Inspector Barnes can attest to that as well. That's the end of my report.
All right. Mr. May, do you have questions for Inspector Harris, Chief Harris?
Chief Harris, you're indicating that Mr. Phillips wasn't TAM certified?
I asked him if he was, and I believe he answered in the negative.
Do you have the records for the commission in there with you?
Not at this moment. I mean, I'm here in the office, they could be gotten.
I'd ask the board to take judicial notice of their own records, which indicates that in fact, Mr. James Phillips is TAM certified and the expiration is 2/25/2022.
Well, Mr. May, if you want us to take judicial notice for our records and go and find it, it's going to take some time. If you have that record, why don't you share it with the board now and your board proffer that he is, and let us use that proffer as the basis for.
Thank you, Mr. Dale. I'm looking at an Anne Arundel County Liquor Board comprehensive report for Klaus's Liquors, and it indicates that James Phillips was certified by a John S. Murray on 2/25/2018, and it expire on 2/25/2022. And that's
tip train.
Okay. Commissioner Duffy, did you have a question about that, Mr. May?
Yes, would he clarify whether or not that was then a certification for tip training or management agreement? Because we are speaking of the management agreement. So are you saying that was tip train or management agreement?
It was TAM certified. The manager's agreement has not yet been charged, and that's part of the problem with the argument that I raised earlier, in that whether we're going to have to now face perhaps another charge because of the improper and overly broad charges that I raised earlier. But no, it's not, Commissioner Duffy, it's not management agreement. That's something else that I'm in the process of dealing with.
Okay, but that's what we were referring to. At least that's what my understanding was, that we were looking for the management agreement.
Okay, well, I was I'm sorry, I misunderstood Chief Inspector Harris. I thought he was talking about TAM and or the manager and the manager's agreement, not just one or the other.
For clarity on the evidence that was presented, Mr. May is an officer of court. He's proffering that there's a document there indicating TAM certification of his client that is still valid. Is that right, Mr. May?
Yes, sir. That's correct.
All right, let's move on.
Chief Inspector Harris, what time exactly were you in the back when this person was, when the bartender was, you're indicating not having her mask pulled up correctly?
Mr. May, I'm looking, and I have to pull the original written violation out, which I can do, and see if I noted the time. I did not, I don't see it noted in the report. I'm showing I was in there, and it's on the back of my written citation. I'll try to get it to where you can see it. I make a note of the times that I'm in there, hopefully to put it on the report. In this case, I didn't, but you'll notice the time that I wrote down when I met Mr. Phillips was 4:50 p.m. on that date. Can you see it?
Yes, sir. Thank you.
You're welcome.
Commissioner Harris, which order are you using to make the allegations of these violations? Because if I'm going to defend them, I need to know which order I'm dealing with.
Mr. May, I think Chief Harris has indicated the rules of the board on his citations that were violated and issued his violations for those. I don't think it's proper for you to be asking him his legal opinion on which executive order. Although Chief Harris did say earlier that he would look up which executive order was in force at that date. So I think if that's what you're asking, that's all right. Any provisions from the executive order or illegal analysis?
I'm not asking for a legal analysis. I'm just asking which executive order I'm defending against.
Chief Harris, you can answer it. I think you already answered earlier.
Yeah, same answer as I gave before, Mr. May. I don't have that exact executive order, but it was the one that was in effect on December 11th and December 14th. I can get you that. As you know, we're now up to executive order number 43, and they change pretty much on a weekly or so basis. But I can get you that if it's, yeah, I just may have to pull all the records out to get it.
Okay, is it the county executive's order or the governor's order?
County executive's orders and the state governor's orders. As you know, if you look at the violations, if they're on the right side, it's county ordinances, rules, regulations, and laws. If it's on the left side, it's the state. And I believe all of these charges, 305, 309, 311, 3.05 are all county rules and regulation violations, as well as 416 illegal conduct. 416, if you notice the way I wrote the violations, refers back to both the state or the governor's proclamation as well as the county executive's orders, because they violated both the county and the state. Hopefully I answered that correctly.
Yeah, you did. Thank you.
You're welcome.
You just, excuse me for a minute. I'm just trying to find in executive order number 38 where it says anything about standing up.
Chief Harris, Chief Harris is aware of the policies for enforcing these executive orders. I don't think the Chief Harris said it specifically says in the language about standing up. I think that's what it means, though. That's how it's been interpreted. Chief Harris, if you're looking at that executive order, are you referring to the provisions about seating?
Yes, and that's been in effect for quite a long time through many of the executive orders, and has just kept being refurbished and moved on to the next one, where it says that patrons who are consuming either food or drink, whether it be alcohol or otherwise, must be seated at the time of that they're indulging or consuming. And it's the same as standing. You've probably heard many refer to, you're not allowed to stand at a bar. You're not allowed to walk up to a table and converse with anybody while they're partaking in their meal, various things like that. And that is in both the governor's proclamation and the county executive's orders. And if you look at the FAQ, or if you want, I can take time, it's going to take a little bit. I can pull the exact FAQ, which is the frequently asked questions provided by the county executive's office, Mr. May. These FAQs answer specific questions about standing and drinking, as well as many other COVID rules and regulations.
Well, I'm just looking, I understand and I appreciate what you're saying, Inspector Harris, but I'm looking at and have looked at 38, Executive Order 38, based on your, and I guess this is more of a legal argument I'll make at the end, because I'm not here to debate with you about the law. That's going to be for the board to decide, and whether in fact 38 in fact indicates that. Additionally, I would suggest and make it part of the record that we're not here charged with citations based on facts and answers, or facts and questions that are promulgated as a guidance by the county executive. Do we have, or Chief Inspector Harris, do we have the names of any of the people who were allegedly in the bar violating these orders?
Other than the employees, no. We make it a practice not to approach the patrons, if at all possible, for both our safety and welfare, as well as, of course, we don't want to upset the patrons of the establishment. I'm sure Mr. Patel or any licensee would not want us going up and asking for names and addresses of patrons. So it's a common practice not to take names unless somebody's involved in a specific incident that would, in my opinion, require it.
How do you identify yourself to the persons, whether it's the employees or anybody else you may be investigating? How do you identify yourself as a inspector?
I do. It's a common practice. I have, this is, I can give you a closer view if you wish.
It's enough.
I got it. Thank you.
Okay. And it is a common practice. I've been a law enforcement officer in the past, and I understand proper approaching to identify. And anytime I've been asked to see the ID card that goes with that, I have that on me as well, and I've been more than happy to extend that.
Have you ever used that to identify, that particular badge to identify at any other time yourself as a inspector or anything else involving that badge?
Of course, I've used that badge. Now, if I understand your question correctly, Mr. May, I use that badge quite frequently to identify myself.
As a liquor inspector, correct?
Yes.
Have you ever used it for anything else?
As a liquor? No, only as a liquor inspector, which is what it is. I can make this easy for you, Mr. May. If you're asking me if I've ever identified myself as a police officer, the answer is no.
I wasn't suggesting that, Commissioner.
No, I'm just trying to help you if I can.
Did you see the barmaid when she was, or the bartender when she was eating, when you walked up to her?
No, she was not eating, and what she said she was eating. That's why she had her mask down. And I was standing, I guess 4.5 feet away. I asked her what she was eating, and she reached under the bar and pulled out a small cup about half the size of a coffee cup and said this. And I said, well, the top's still on it. And she said, well, I was about to eat it. And that was Miss Marcia Smith, I believe is her name. She had no utensil or anything else at that time that she showed me.
Mr. Aronson, could you please, on the evidence list, pull up the MP4, the last three digits, 808, please?
Okay. Did you want me to play the?
Play the tape, please. Yes. Now, Chief Harris, this is when you're in, you said you had 450 on the top, on the back of the citation, correct?
Yes, I did. I think it was 450. Yes.
All right, now she's eating right there, correct?
Yes.
You can see her.
It appears to be, yes. I agree.
She's got a cup with the, like, some kind of food in her hand.
Yes, it appears that way, correct.
And now she's gonna take another bite of it?
It appears to be that way too. That's not, I don't believe that's the cup she showed me, Mr. May, if that's what you're inquiring about.
Well, this is
She may have had that cup and may have eaten from it, but when she told me that, she didn't show me that cup. She showed me another one that has seal on top.
Okay, thank you, Mr. Erickson. I don't have any other questions of Chief Inspector Harris.
All right, thank you, Mr. May. Mr. Chairman and Commissioners, do you have questions for Chief Harris regarding the report?
Mr. Chairman, I have no questions.
Commissioner Duffy, I have no questions.
Commissioner Pilkins has no questions either.
All right, Mr. May, you can present your case through testimony or proffer, a combination thereof.
Mr. Dale, I'd just prefer to make it at this point as far as argument as to both everything. Unless the board has some other procedure they want to.
Sure, so this argument will be about both charges, both violations.
We start off with the premise that the 11th that Commissioner Harris was referring to, there's no indication, in fact, there was any alcohol outside of the establishment. He didn't check whatever the contents of the items that he was seeing that these people had. Mr. Patel took immediate steps to make, even whether it was alcohol or not, but what I'm suggesting, it wasn't proven by the board or proven to the board that in fact there was a violation. As far as that particular case is concerned, there is we all go back to the original arguments as far as the sufficiency of the charging documents, and also would point out that 3.11 or 311B, I believe that it requires it to be alcohol. And without there being any proof at all that in fact the outside, what was being consumed outside was alcohol, that the charges are insufficient and should be dismissed. Additionally, as far as the mask situation on the 14th is concerned, clearly at the time that Chief Inspector Harris was in there indicating that the mask was down, persons are, I believe, under the orders allowed to make or to have the mask down when they're consuming food. She was behind a screen, a plexiglass divider. And I would suggest to the commission that, in fact, what was indicating that what was shown in the video and what Chief Inspector Harris were indicating would not be a violation of the regulations that are before the board. We also adopt all the earlier arguments made by Mr. Hartman in that these violations, 6 of the 7, I believe it is, have to do with the COVID violations. And as such, would suggest to the commission that in fact, they are not, they haven't been made out to the standard of proof which is necessary. Once again, Mr. Dales and I are going to disagree as to what standard of proof that may be. Additionally, 4.16, the violation there, and I'm going on the basis that I'm presenting my closing arguments, so that I'm guessing that the board or the commission has received all the evidence it's going to receive. And 4.16, I would suggest sufficiently has not been made out, because we still don't know and told which order in fact was violated, which goes back to the earlier argument about the sufficiency of the charging documents themselves. These are not hard things for the commission to deal with and to fix. I'm suggesting that maybe it hasn't been raised before, that when the board is going to bring people before violations, that the licensees ought to know what they're being actually charged with, so that they can defend against this. And then down the line, if they're charged with the same thing, where you have the situation where they're charged twice with the same thing, when all you have is a date, and then you don't have what actually the violation was. It could be a circular type thing where things are just not ever finished as they should be. Based on what has been presented to the board, I would suggest that none of these charges has been made out in a sufficient basis to find the licensee guilty or to have committed any of the violations as alleged. And with that, as far as closing arguments, I would defer to Mr. Hartman.
Thank you, Mr. May. I just wanted to add on and discuss the implication of the existence of the governor's executive order and the county executive order. You know, these are emergency powers that are in play here, and they come with standards because you're generally not allowed to simply walk around and shut down businesses for violations of things that are not otherwise illegal. The concept that drinking while standing or drinking while seated too close to one another are concepts that are foreign to us as a means by which you can incarcerate someone, close their business, fine them. That they only exist because of the county and the governor's executive orders, which are only authorized by emergency powers. Now, as I said before, when these are litigated in court, and you guys have taken on the role now of a court, because you are deciding whether or not there's been a violation of the governor's order. And only the courts have the authority to do that. But if you're going to do that, then you have to follow their rules. And the rule is very clear that in Governor Hogan's order of April 5th, 2020, it states that the county health officer, and if you guys believe you have the authority of the county health officer, so be it. But even the county health officer has to determine that a business is unable or unwilling to operate in a manner that does not pose an unreasonable risk of exacerbating the spread of COVID-19. That's a horribly tortured sentence, but it means that what it means is that a reasonable, if the business is conducting itself in a manner that poses a reasonable risk of exacerbating the spread of COVID-19, then you don't have any authority to take any action at all. You have to establish this standard under the governor's order, that it poses an unreasonable risk of exacerbating the spread of COVID-19. We have heard no testimony, whether it be lay opinion, expert opinion, whether there has actually been any COVID cases at this place, or whether there's a threat of it. And there has to be substantial evidence to actually take action to limit a business, close it, fine it, penalize it, or conduct any sanctions. The governor's order then goes further and says, if a political subdivision wishes to restrict further, because remember, the governor's order says 50%. There's no doubt here that if we were living under the governor's order at this time, there would be no violations, or because of the other sanctions as well. So if the county wants to go to 25%, which they did, they can only do so if a determination is made that it is necessary and the actions taken therewith are necessary to save lives and prevent the spread of COVID-19. We don't have any testimony of any kind of these. You're not simply permitted to just walk in and say, I saw some guy stand up and with a drink, and now I can shut him down or fine him or take whatever action we can have. There are very strict legal standards which are imposed by the legislature, by the governor, and by the county executive. And there has been no evidence of any kind that these have been even alleged, much less met. It's not enough to simply say it, of course, but that wasn't even said. There actually has to be clear and convincing evidence to prove it, because this is an administrative hearing at which property can be taken. And in fact, as Mr. May and I have pointed out, the reality is people can be put in jail. So but if you disagree that it's a criminal standard of beyond a reasonable doubt, there's no doubt that a typical administrative agency where sanctions can be imposed falls under the clear and convincing. There is no evidence. There's no evidence of violation of the alcohol rules. And anytime you get into the COVID rules, you guys you have very high standards to meet, which is why the restaurants stayed open in this particular county in December and January and February and March, because they could not meet that standard. The county could not meet the standard to prove that these restrictions were necessary to save lives and spread COVID and avoid the spread of COVID-19. There hasn't even been an attempt here. So under any set of circumstances or any stretch of imagination, there has been no evidence put on to meet the high burden that this particular board has undertaken to exercise jurisdiction actually granted to others. But if you're going to exercise it, you got to follow the rules that go with it. So I second Mr. May's argument that there has been no legitimate evidence presented that comes anywhere close to meeting the standard. And we request that this board recognize that and deny the sanctions and dismiss the citations. And by the way, just when you're looking at the citations, as Mr. May pointed out, all they say is that they essentially say that you've broken the law. Now, imagine if you're charged and with a potential incarceration, and all it says is that you have violated the governor's county executive orders. There are, as he pointed out, there are 42 of them, each one of them long and complicated with a lot of incredibly difficult language. No facts anywhere in any of these documents in order for Mr. Patel to defend himself. And he's facing potential incarceration, loss of his license, loss of his livelihood, all for the fact that he allegedly violated the law. You simply cannot do that. That is so fundamentally unconstitutional that it denies a due process for Mr. Patel to actually defend himself. So this can't go any farther than where it's gone right now. We respectfully request that you deny the citations. Thank you very much.
Thank you, Mr. Hartman. So, Mr. Maloney, we'll move to deliberation and decision here on both the violations. But before we do that, just a second comment on the legal standards raised by Mr. May, Mr. Hartman. As I said earlier, these are very interesting arguments about what the standards should be, and essentially that there should be a different standard under the executive orders when we're talking about applying our own rules via the executive orders. And they raise interesting questions as to the requirements for authorization and guidance in the state of emergency. Those are issues that that I think we would need to be fully briefed, and we'd have to have the benefits of fuller argument to make a decision that for me to advise you comfortably that we have to use these higher standards in the case of the executive orders. But with Mr. Hartman, I do understand your rationale and your logic and your legal argument there. In this instance, though, we've already ruled, as we ruled previously, the standard, we should use our usual legal standards that we would use for any kind of a health violation or a safety violation or violation of the law. That should be the standard you consider in this matter, and then determine whether the charges were specific enough, and whether which I actually already did in dismissing that motion, and then determine whether the facts rise to the level of the standard we ordinarily use for regular violations related to public health, safety, welfare, and violations of law under our rules. Mr. Arvin and Mr. May can appeal and argue the issues of the legal issues that he's raised a couple of times now. With both Mr. May and Mr. Arvin have raised are good issues, but can be decided by the court in any proceeding that Mr. Arvin and Mr. May choose, whether petition due for review or some other act. So with that, I'll turn it over to you.
Thank you. Yeah, there's a lot to unpack here, no question about it. I'm just going to basically say that we've had a mandate to assist the health department and to inspect and to look for COVID violations, exactly as you mentioned, Mr. May. So the point was we found some violations and in sanitation and safety and public welfare. And your arguments are good. And I think, but in a very simplified manner, we went in and took a look at what was going on, one of our inspectors, and came up with what we did. Now, if you look at an ordinary police, I guess, docket, and if you're charged for jaywalking, they simply check jaywalking and you've got to come in and defend yourself, or whether you were speeding, et cetera. I think our forms are, violation forms are within good conduct, and they are brief, but they're in sync. So I'll turn it over to the other commissioners if you have anything to say, and we can then rule upon that.
Well, Commissioner Pilkins, I'll jump out. I just see a lot of obfuscation here. I don't buy into many of the arguments that I've heard tonight. I just can't believe that the health officer is the only person who can issue citations when we have a whole county and thousands of people to deal with, and they ask the liquor board to help them with their administrations. So that's my personal feeling on this at this point. So perhaps Commissioner Duffy has a similar or alternative position.
This is Chief Commissioner Duffy. I mean, it's listen to the evidence as well as to Chief Harris and Chief Bourne's presentation in reference to the evidence that they presented. I honestly feel that Chief Harris and Inspector Barnes did an exceptional job in going out and giving them management, the licensee, the opportunity to correct and to verify everything that they found and saw. And so I think they did a reasonable job in providing and substantiating all their comments and the action that they took. And one of the questions that I asked was, as Mr. May had stated, did Chief Harris ask what was in the cup? So to me, the licensee should have asked that question as well if he wanted to verify what was in or not in the cup. I think it could have been twofold, but both individuals could have asked and should have asked. But irrelevant of that, I do think Chief Harris and Inspector Barnes did an exceptional job in pointing out the violation. And that's all I have to say in reference to that. And I'm willing to vote on a motion that would be made by the commissioner or the chairman.
I have one quick question. Did Mr. Phillips ever get his management agreement done?
Mr. Pilkins, Commissioner Pilkins, yes. Here's the situation. I emailed down to the commission today 5 management agreements. Mr. Phillips is one of those. I did talk to Administrative Assistant Janet Gagnon, and I have to take the originals down, but so that there would be something on file at the commission, the 5 management agreements have been emailed, the copies, obviously, I have to bring the originals down to the commission. But Mr. Phillips is one of those persons.
Thank you, Mr. May.
Yes, sir.
Mr. Hartman, you had your hand up a while ago.
I did, thank you. And this could help answer some questions for me. I've heard a couple of references to the health department asking for your help. And we have found no formal delegation of authority, but it wouldn't be the first time that we've looked for something that was there and missed it. So, I mean, I asked Mr. Dales and Mr. Fraley, is it your position that there has been a formal delegation of authority from the county health officer to the liquor board? Because that would be something that would be important for us to know. Well, we're just, like Mr. May said, we're coming in this trying to figure out what all the rights and rules and responsibilities are. We haven't found any such delegation, but we could be wrong.
I understand why you're asking, and I don't have a problem with Chief Harris explaining whether inspectors have received a formal request. But also, I don't think it's necessary for us to answer that question or take a specific position on whether or not we find the authority to have been delegated. And I remind you that, especially if you're going to be appealing our administrative decision, that the questions of law will be reviewed de novo. And if you're seeking an injunction, I don't think it will turn on whether we took a certain legal position or not. Certainly, legal issues will be relevant again, but our position on that, I don't think will be on that smaller sub issue will be as sensitive to your case.
I agree with you, Mr. Dales. I don't think that if one of these gentlemen ladies tells me that in fact they think they have authority, but they do or they don't, doesn't really matter. I was just curious if everybody's certain because there's a particular document or something that we didn't have. I certainly would like to know if I'm wrong. So,
Mr. Fraley, correct me if I'm wrong. I think we could leave that for discovery or any of the procedures or evidentiary procedures in court, unless you want to have that out now.
No, Mr. Dales, I appreciate it. I don't really have anything to add.
Okay.
Right.
Okay, that's all right. That was my question. Thank you.
I've got to excuse myself, Mr. Fraley, Mr. Chairman. I'll be back to this meeting in a minute. I need to go now.
Okay. All right. So just for clarification, it's back to us, to the commissioners to continue the discussion. If there's any other discussion out there with regard to what we've discussed pretty much all night, now's your chance. We're good.
I just want to make a comment again regarding the violation where we discovered the lack of management agreement was in December of 2020. And the document just got delivered on March the 9th of 2021.
Yeah.
Just wanted to make that that statement in some neon lights there. I think that's an important thing. It took all that time to get a management agreement done.
Okay, any further discussion? Thank you.
All right, if there is no further discussion, we can declare the public record closed at this point, and now deliberation and a vote would be appropriate.
Well, I think we've deliberated to a point where we may be ready to make a motion. At this point, I think, as I had indicated before, and I think Mr. May had said that we're specifically talking about COVID violations, and it's under the governor's and the county's mandate, county executive's orders. So I'm going to move, and here we are in March, and probably in another 3 months, we won't have to worry about what we're talking about today, but we're talking about what happened back in December. And I'm going to move that we fine Claus's Liquor $500 for those COVID violations. Is there a second out there?
For clarification, is that $500 for each violation?
No, it's 500 for all. If I may, Mr. Chairman, just to remind you, there are two separate violations, one on the 11th and then one on the 14th. And that's just a reminder, that's all. Okay. We'll put them both together and it'll be $250 for each, 500 for the total. Do I hear a second on that or for discussion?
This is Commissioner Duffy. I would love to discuss the issue of the fine in and of itself. I find that the violation were more serious than to address it as being $250 per violation. And I would like to make a motion to discuss the fact of that we make each, because of the fact that at one point in time, it would say that the first offense would be minimum of $500. And so therefore, I would like the discussion to be based upon the fine in and of itself as $500 per violation, and that it'd be a total of $1,000 versus that of $500. That's the discussion that I would love to have.
Well, that's in a form of a motion. Thank you. Is there a second to that motion?
Yes, Commissioner Pilkins seconds that motion from Commissioner.
Any further discussion? Those in favor say aye.
Aye.
Aye. The motion is carried. Thank you.
Thank you.
Thank you, everybody. We're getting ready to call the next case. All right, the next case, Mr. Aronson, will be the rumor mill. Okay. Next case is the rumor mill. This is a change of officer. It's known as Next Gen Foods LLC. Anthony Casalino is a authorized member with Inspector Franklin J. Faulkner as the inspector for the liquor board. This is a change of officer. Currently, Carl Casalino is a member at 4730 Mountain Road, Pasadena, Maryland, 21122. This is a Class H license, beer, wine, and liquor, entertainment, and Sunday license. There is a restriction. There is a restriction on this license dated 4/10/2018. It says no dancing, dance floor, or bandstand. All music must be acoustical. All employees who serve alcohol beverages must be certified in alcohol awareness. Anyone wishing to testify for or against, please come forward and raise your right hands, please. Mr. Casalino, can you turn your video on so we can see you, please? All right, thank you, sir. All right, and the other Mr. Casalino, Carl, I see you're on now. Okay, would you all three please raise your right hand, or all two raise your right hands? Do you solemnly declare and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, please state your name and address if you're both going to testify, please, for the record.
My name is Carl Casalino, Casalino, 8295 Windermere Drive, Pasadena, Maryland, 21122.
Thank you.
And my name is Anthony Casalino. My address is 8295 Windermere Drive, Pasadena, Maryland, 21122.
Okay, thank you.
All right, gentlemen, now's your time to present your case. You can either do so. It looks like you both are likely going to proffer your case, so please, the floor is yours.
Okay, we're having the name change of the license. When I originally purchased Vandy's, which became the Room Meal, we did a transfer of license. I've been the sole person on the license. Recently, we've now entered into a purchase of a second restaurant that at a later date will be applying for a liquor license. I've been informed by the liquor board that I cannot be on both licenses or on either license since I'm have ownership in both restaurants. So as a result, my son Anthony is the manager of the Rumor Meal, and he has become a partner in the business as of this past February. So we are asking that the board allow his name to be on the license and mine be removed.
The other Mr. Castellino, do you have anything to add to that?
No, I do not this time.
Chairman Maloney, do you have any questions for either of the?
I have no questions.
Any other commissioners?
Commissioner Pilkins has a question, and it's my ignorance, but I might ask the attorney. The documents that are filled out when they apply for a license says that there can be no pecuniary involvement in a second license. But not having them on the license yet having an investment in, isn't that a pecuniary involvement?
Respectfully, Mr. Pilkins, I have not had the opportunity to review these materials. I didn't get them until late yesterday. That would have to be a question for Mr. Dales. So I haven't been able to review the corporate documentation that was submitted with this transfer request at this time.
This wasn't specifically about the Castellinos. I've seen it happen before, and I've never asked the question. And I hate to bring it out now, but that's where I'm stuck on this particular license, is just removing the person from the license, yet having him having pecuniary interest in the second restaurant. It's probably okay. I just needed to have a little. Yeah. So I'm going to presume that it's okay at this point, but I did want it on the record that that's a question that I have.
I have it raised.
Is that Judy?
Yes, sir. If he's only an investor in either a Class H or Class B license, he can have a pecuniary interest in as many as he would like. I didn't know if Mr. Anthony Castellino was on the deed to the property.
He is not. He's a member of the LLC, Next Gen Foods. He's a 1% member.
Mr. Perlin?
Yeah, that should be fine.
Okay.
Yeah, should be fine. Thank you for the clarification, Ms. Hagner. I appreciate it.
No problem, sir.
And apologies for being unable to answer your question, Mr. Pilkins.
It's quite all right. I didn't mean to put you on the spot.
No, it's quite.
I thought I was the only one that didn't know
That's
the
what I'm
answer.
here for. I just apologize that I got thrown in the hot seat right away without having the opportunity to review everything. Okay. So are there any additional questions from any of the board members at this time?
No question from the chair. And the chair will make a motion that we grant the change of officer for the Rumor Meal. And do I have a second?
You do. Commissioner Pilkins, second.
Commissioner Pilkins. All those in favor say aye.
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 Pilkins.
Motion is carried.
Thank you very much.
Congratulations. Good luck.
Good luck, gentlemen.
Thank you.
Appreciate it.
Wayne, you're muted.
Thank you. Chief Wayne Harris, Arundel County Liquor Board, calling the next case, the Green Turtle Sports Bar and Grill, known as GTP Licensing LLC, Stephen R. Shue, member, and Inspector Franklin J. Faulkner, liquor inspector. This is a change of officer. Currently, Derek J. Fink, authorized member at 20 Magothy Beach Road, Pasadena, Maryland, 21122. This is a Class BLX, which is a beer, wine, liquor, and also has an entertainment permit or license. This is a non-restricted license. Anybody wishing to testify for or against, please turn on your video. Thank you. And raise your right hand. Thank you. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, please state your name and address for the record.
Stephen Robert Shue, 1716 Jorick Road, Gibson Island, Maryland, 21056.
Thank you very much, Mr. Fraley.
Okay, Mr. Wise, I assume you're here on behalf of the applicants. This is your opportunity to present your case to the board. You can do so either by way of proffer or by testimony. The floor is yours.
Thank you, Mr. Fraley and members of the board. My name's Steve Wise. I'm an attorney. I'm here on behalf of GTP Licensing and Mr. Shue. I'm going to ask him just a couple of questions, and then I think the board will have what it needs. We've submitted all the documents that I believe are required, and those are in possession of the board. Mr. Shue, you have filed an application to change the name on this license from Mr. Fink to yourself. Is that correct?
That is correct.
Okay, and with that, you understand the responsibility that comes with being the named licensee for this establishment. Is that correct?
I do. That's correct.
Okay. With that, members of the board, we would ask you to approve Mr. Shue as the new named licensee and officer on this license.
Okay, thank you. Any preliminary questions from the chairman?
No questions.
Commissioners Pilkins or Duffy?
Yes, Commissioner Duffy, I have no questions.
And neither do I. I went through the package. It looks really good. Thank you.
Yeah.
Okay, well, seeing no additional questions, we'll declare the public record for this particular matter closed. Deliberation and a vote are appropriate.
I make a motion that we approve the change of officer for the Green Turtle Sports Bar. Do I hear a second?
Yes, Commissioner Duffy, you second the motion.
Okay, all those in favor say aye.
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 Aye. The motion is carried. Congratulations. Good luck.
Thank you very much. Appreciate it.
Take care, Steve.
Now,
Take care.
the
Bye,
next
guys.
case is the is Mr. Shue as well.
Oh, okay.
Stay on, Mr. Shue.
Oh, sorry.
It's going to be Smashing Grapes Kitchen and Wine
Forgot.
Bar, known as GTG Licensing LLC, Stephen R. Shue member. This is a change of officer, currently Derek J. Fink, authorized member, 2383 Brander Mill Boulevard, Gambrels, Maryland, 21054. And you've already been sworn in, and so we can just go forward.
You want me to proceed, Mr. Fraley?
Yes, Mr. Wise, I appreciate it. Again, you have the opportunity to present by way of proffer or testimony. The choice is yours.
Okay, and again, we are changing corporate officer here. We've submitted all the materials, which I believe the board has, and I'll ask Mr. Shue the same questions. Mr. Shue, you're aware that we've submitted an application where you will become the named licensee and corporate officer for Smashing Grapes in Gambrels. Is that correct?
Yes.
Okay, and you're aware of the responsibilities that come with being that named licensee for that location, correct?
Yes, that's correct.
Okay, and with that, we would ask the board to approve the change of corporate officer for this location.
Thank you, Mr. Wise. Mr. Chairman, any questions for Mr. Wise or Mr. Shue?
No questions.
Okay. Commissioner Duffy, Commissioner Pilkins?
Yes, Commissioner Duffy, I have no questions.
No questions for
Okay, and with that, we'll again declare the public record closed for this matter. We'll move to decision.
Yeah, I make a motion again to change the officer of the Smashing Grapes Kitchen and looking for a second.
Commissioner Pilkins seconds it.
All those in favor say aye.
Aye.
Aye. Motion carries. Thank you. Congratulations.
Thank you, gentlemen.
Thank you.
Thank you very much. Appreciate it. Have a nice evening.
This is Chief Wayne Harris, calling Summers, known as D&D Summers, Inc. Denise Tenney is president, Inspector Roland Marshall. This is a change of officer. Currently, Donald D. Summers, president, treasurer, and secretary at 910 Main Street, Baltimore, Maryland, 21226. This is a Class D license for beer, wine, and liquor with dancing and Sunday privileges. This is a non-restricted license. Anyone wishing to testify, please raise your right hand. Ma'am, raise your right hand.
Denise.
Thank you. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, please state your name and address for the record.
Denise Tenney, 5122 Mountain Road, Pasadena, Maryland, 21122.
Okay, thank you very much. Mr. Fraley?
Thank you, Inspector Harris. Mr. Bittner, I see you here tonight. Floor is yours. You can proceed by way of proffer or through testimony. Go right ahead.
Thank you very much. Mr. Chairman, members of the board, good evening, and may it please the board. I'll move in our application that was filed on or about January the 21st for this change of officers, transfer in effect for D.D. Summers, as well as all the supporting documents, which I believe makes out a complete application for this change of officers transfer. If I may, by way of proffer, I'll tell you, as you heard, Ms. Tierney is a resident of Pasadena. She's been operating Summers under a management agreement for about the last year. She's taken it over recently, when about October. She tells me that they've cleaned it up. They're bringing in some new clientele. They haven't changed any of the hours. They haven't had any issues with the operation. Ms. Tierney has reviewed all the rules and regulations of the board. She's familiar with them. She's completed alcohol awareness. So I believe that she'll be a credit to the hospitality industry here in the county, and she'll operate Summers in appropriate fashion. We're happy to answer any questions.
Okay, with that, Mr. Chairman, any questions? Mr. Chairman, you're actually on mute.
The chair has no questions.
Commissioners?
Commissioner Pilkins has a question. The diagram of the inside of the premises is rough. Is there any chance that we can get for our files a more professional layout so we know what distances really are, and that it's very hard. I mean, I can see everything here, and I'm going to probably be okay with it, but I just would like to have something more stable than this hand-drawn document. Can we do that in the next time, or in the next couple of weeks or something?
You be happy to try to accommodate you and the board in any way. Are you asking for something that they go to the expense of having professionally done, or would you just like?
It just needs to be done better than it is. It's just
okay.
Hand drawn, took a couple of minutes to do. The measurements, I presume, are correct. I don't expect them to spend any money on it, but there's ways to do that. It makes it much clearer to everyone. So.
Okay. We want to accommodate you, Commissioner, and I'm not sure. The handwriting may be a little shaky, but I'm not sure what isn't clear.
I just need something that's so I can see. I want to see the relationships, not just the things. I don't know what the perspectives are on here. I see a bath, rooms, walk-in box. But they're not shown at the correct size. I'd like to know how they fit into everything so that I can understand it better. I'm not saying there's a problem. I'm just saying I need that cleaned up.
We're happy to comply.
Thank you.
This is Commissioner Duffy. I have no questions.
Okay. There are no additional questions from the board members. We'll declare the public record closed for this matter. Mr. Chairman?
Yeah, I'd like to make a motion that we approve the change of officer for Summers.
Commissioner Pilkins, second.
Second, okay. All those in favor say aye.
Aye. Commissioner Pilkins.
Motion is carried. Thank you.
Thank you, Mr. Bittner, Ms. Summers.
Thank you all. Please be safe.
Bye.
Good luck.
All right.
Thank you so much.
This is Chief Inspector Wayne Harris calling the next case, Bonchan known as Faith Union LLC, Ming Yon Lin, managing member, and June Lai, member. This is Inspector Jason McCarthy's area. This is a new license located at 1153 Route 3 North, space number 50 in Gambrills, Maryland, zip code 21054. This is a Class H license, multiple beer, wine, and liquor with entertainment and Sunday. Mr. Praley, it's all yours, sir. Oh, I'm sorry. Anyone wishing to testify, please raise your right hand. I apologize.
Not a problem.
Okay. There you go. I can see you now back there. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Yes, I do. Yes, I do. All right. Please state your name and addresses one at a time for the record, please.
My name is Jing Lin, and my address is 2401 Banbury Lane, Gambrills, Maryland, 21054.
Thank you. Next.
My name is Mingyun Lin. My address is 2401 Banbury Lane, Gambrills, Maryland, 21054.
Thank you very much.
My name is Martin Johnson. That's MartinJohnson. My address is 9869 Diversified. That's DIVERSIFIED Lane, Ellicott City, Maryland, 21042. And just preliminarily, this is brand new equipment. We tested it. If you have any problem hearing us, we can turn ourselves up.
I think you're in pretty good shape.
Good.
Thank you.
Thank you.
That sounds good, Mr. Johnson. Thank you. And now's your opportunity to present your case by way of a proper or any other method deemed appropriate. The floor is yours.
Thank you, Mr. Praley. I'm not an attorney. I'm a liquor license consultant. I'm often hired by law firms to help out. Your primary applicant, June Lin, has a presentation, and she can call me as a witness, if that's okay with you.
That's acceptable.
Excellent. She is going to do some reading because she wants to make sure that everything that she wants to say gets said.
Sure.
If you have any problem understanding, please let us know.
All right. My name is Jin Lin, and my husband name is Ming Yuan Lin, and I are the application for this license. And I have lived in Arundel County for more than 2 years. And I registered to vote in Arundel County too. And I have been a United States citizen for 12 years. So we have been operating our restaurant for more than 2 years. Under COVID conditions, we only over takeout servers. And after COVID, we will return to table server and the takeout. My husband and I will continue to personally operate and manage the restaurant. We have no separate manager. I am certified in alcohol. And my husband, he was taking Mr. Johnson alcohol class on March 22. We will send his certificate to you when he receives it. And all application package include my alcohol certificate, a menu, and a set of 7 photos for your review. On request, this item be exhibit.
She's asking for them to become exhibits. They were already sent to the board, the menu, photos, and her alcohol certificate.
And we have worked with the Miss Johnson on our liquor license project for more than 1 year. We have studied the rule and the law with him. And the minimum age to serve or drinking alcohol is 21. And we know the minimum age to serve alcohol is 18. Mr. Johnson, he taught us how to use the ID checking and the ID checking book and the ID checking tools. And also Mr. Johnson helped us to choose our alcohol policy.
we have an alcohol policy book for our company. Employee will be required to learn the policy and sign for their copy. Employee involved in the alcohol server will take the alcohol class after hiring. Either my husband or I, or both us, we will be the restaurant when it is open for the business. We know that we are 100% responsible for any problem at our restaurant. And we have 14 tables that set up 38 people. And we have dine-in bars that set up to 8 people. All right, and also we have 3 TV that will have news and the sport online. All credit hours, Tuesday to Thursday, 11 to 9:30. Friday, Saturdays, 11 to 10 o'clock. Sundays, 12 to 9. We close Monday. Right now, we have 12 employees, and we plan to return to 15 employees after COVID. We are asking to serve alcohol to adult customers who ask for it. When we have table server, we will receive requests from all customers to serve beer or wine with all dishes. Sometimes we receive requests for mixed drink. The customer who asked have been disappointed that we were not able to serve this drink. If we are granted a liquid license, we have no reason to believe that there will be any negative effect on another business or home in the area. We will be quiet indoor the restaurant. There is a lot of available parking. The shopping center is well lit at night. There are no home nearby. We have asked Mr. Johnson to help us make sure that we have safe alcohol servers. We can call him for help anytime, daytime, nighttime. Yeah. I would like to call him as the witness after I answer your question.
The applicant is ready to answer any questions you may have or to call me as a witness.
The choice is the applicant's. If they want to call you as a witness, they're certainly within their right to do it, or we could turn right to questioning. It's completely up to her.
Okay.
This is Commissioner Duffy. I do have one question. And Chairman Maloney, I apologize. If you have questions, please.
Oh, go ahead.
Well, Mr. Duffy, before we get to that, I just want to make sure that the applicants are finished with their complete presentation before we turn to the board's questions. So I was just merely asking if she wanted to call Mr. Johnson as a witness, which she had alluded to previously, or if she was finished, we could then turn to the board for questions.
Mr. Johnson, please tell the board your background and anything that you believe is important in this case.
Okay. Thank you. Members of the board, my name is Martin Johnson again. My background, very briefly, is I was a police officer and detective for 25 years. I enforced alcohol laws for those 25 years. And I was also the head of retail alcohol inspection for the Howard County Liquor Board and the County Council. I stopped doing that. I retired in 2009. I help people in small businesses who are trying to get into the alcohol business. I can tell you that this place, we've been working on this project for over a year now. First of all, for the record, I am authenticating the exhibits. If you need authentication, the 3 exhibits, the menu, the photos, and the alcohol awareness certificate. I am the person who provided them to the board. They are authentic and they accurately represent what they pretend to be. The place has been open for 2.5 years without alcohol. I have been here on a number of occasions when customers have asked for beer or wine, once in a great while a mixed drink, and they're always very disappointed when they can't get that with their food. So I've actually seen that myself. I also was here on one night and we got the 10 supportive signatures immediately. Lots of people have asked for alcohol to be served here. I'll tell you right now, I will be with these people while they have their license, if it's granted. Anything they need, they can call me. I don't charge anything. I don't want any money. Just they can call me 24 hours a day, 7 days a week to get any kind of help. They're a good little family, mother, father, 2 little girls. They're very stable and they're completely responsible whenever I've asked them for anything. That would be the sum and total of my testimony. I'm also available for questions if you wish.
Okay. Thank you. With that, I will now turn it over to Chairman Maloney or any other commissioners for questions of the applicants or Mr. Johnson, their witness.
This is the chairman. I have no questions. Thank you for that presentation.
Commissioner Pilkins, I'm very, very pleased with your presentation. Thank you.
Well, prior to my question, let me piggyback on the chairman and the commission comments. I was very impressed with the package as well as the presentation, and I love the menu. And you will definitely see me in your establishment for the food. I love the menu, and it's very reasonable, very, very much. And I live in the Severn area, so you will see me often eating there. My question is, I did understand you to say the date that you would be open as well as closed, but I didn't hear a time of the operation. So if you could repeat that again, as far as the time that you would be open. I do recall you saying that you would be closed on Mondays. I think it was Monday that you would be closed, but I didn't hear the hours of operation.
That's right, Commissioner. It's Tuesday through Thursday, 11 a.m. to 9:30 p.m. Friday and Saturday, 11 a.m. to 10 p.m. Sunday is 12 noon to 9 p.m. and we are closed on Mondays.
Correct. Okay, thank you very much.
Commissioner Pilkins has one comment. The Department of Assessments and Taxation's document that's in the package shows an August 6, 2018 date. We'll need one that has something within the last 6 months before you will get your liquor license, if in fact we approve it.
Commissioner, what is the name of that document, if I may ask?
It's the state of Maryland. It's the Department of Assessments and Taxation, and where it states that they are up to date on their taxes and withholdings and things like that.
Okay, very good. That's a good standing letter. Got it.
Yeah.
All right. Any additional questions for the applicants or Mr. Johnson from the board? Okay, well, with that, we will declare the public record portion of this closed, and we will turn it to the board for deliberation and decision.
I'll make a motion that we grant the new license to Bonchan. And looking for a second.
This commission definitely, I second.
Any discussion further? All those in favor say aye.
Aye, Commissioner Pilkins.
Aye. We got 2 ayes. We have a 3rd eye. Well,
aye.
All right, 3 ayes. Carries it. Thank you very much.
We had a moment.
Dispense.
I want to make one comment before you go. 2 doors down, I had a very successful restaurant in that shopping center for 10 years. So I hope that you have the same great luck I had when I had my business there.
Thank you, Commissioner. They do a great job. They really do. We've got more people coming in and asking, please, when are you going to open up the tables again? They want to come in and eat.
Yeah.
They take out an awful lot. So thank you very much.
All right, thank you.
Thank you.
Thank you for considering all requests. Thank you.
Good luck to you.
All right, thank you, everyone. Next case, True Food Kitchens, known as TFK Maryland LLC. This is Christine M. Barone, member, authorized person, Elizabeth M. Werner, member and authorized person, Inspector Alan Levy with the Anne Arundel County Liquor Board. This is a new license located at 1906 Town Center Boulevard. number 4110 in Annapolis, Maryland, zip code 21401. This is the Class B license for beer, wine, and liquor, entertainment, and Sunday license with outdoor dining. Anyone wishing to testify, please raise your right hand. Okay, do you solemnly declare and affirm under the penalty of perjury that I think that's your other hand, ma'am. Thank you. Do you solemnly declare and affirm under the penalty of perjury that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth? Hey.
I do. I do.
Ms. Werner, you also?
I do, yes.
Please state your name and addresses one at a time for the record.
Good evening, Christine Barone, 6203 East Turquoise Avenue, and that's Paradise Valley, Arizona, 85253.
Thank you. Next.
Christina Fox, 3535 South Ball Street, Arlington, Virginia, 22202.
Okay, thank you. Ms. Werner.
Elizabeth Werner, 1287 Cape St. Clair Road, Annapolis, Maryland, 21409.
Thank you.
Okay, Ms. Barone, Ms. Warner, Ms. Fox, this is your opportunity to present your case to the board, and you can do so by way of questioning or by proffer. The floor is yours.
Okay, thank you so much for having us join this evening. And we are presenting our restaurant, True Food Kitchen. So we have 36 restaurants across the United States. We're very excited to be opening in Annapolis, Maryland. We're already opened in Bethesda, Maryland, as well as in many other states across the US. I actually grew up in Annapolis and went to Central Middle School and South River High School for a bit. So I'm excited to be presenting this today. My responsibilities within True Food, I'm the Chief Executive Officer of the company, and we are a healthy restaurant. We were founded by Dr. Andrew Weil, who's the father of integrative medicine, and so all of our dishes are very nutrient rich, and we have healthy fare in addition to great fresh cocktails, often made with fresh squeezed juices, and a wine list that also represents Mediterranean countries that our menu is based upon. So that's a little bit about our restaurant. Then going through, we're building a large restaurant in Annapolis like our other restaurants. We will have 146 interior seats with 16 seats at the bar, 14 bar seats, and then 2 ADA seats at the bar. We also have a lovely patio. It's an outdoor patio that will be covered or enclosed in 3 sides with some beautiful gates in the front of it. And the patio will have 70 seats with separate entrances, so all serving will obviously be done from the restaurant and with an interior door onto the patio, excuse me. We just proposed hours of operation are Monday through Thursday, 11 a.m. to 9 p.m., Friday, 11 a.m. to 10 p.m., Saturday, 10 a.m. to 10 p.m., and Sunday, 10 a.m. to 9 p.m. We will be hiring approximately 120 employees to run the restaurant for us. Christina Fox, who's on the call, is our regional manager for the area, and she will be overseeing the hiring of those employees along with our training teams. We typically are 70% food, 30% alcohol at our restaurants. And then we will we participate, every employee that will be serving any alcohol or have anything to do with alcohol will be part of RAM training. So we train all of our employees before we open the restaurant and then on an ongoing basis. Let's see. We're anticipating opening in June of 21. So the restaurant is currently under construction at Annapolis Town Center and should be ready for occupancy by that point. And that's really all I have from a presentation standpoint, but I'm happy to answer any questions.
Okay, thank you. If there's nothing else to add at this time, turn it over to Chairman Maloney for any questions.
This is the chair, and I have no questions. It looks pretty good.
Commissioners Duffy or Pilkins, any questions?
No, the package looks like you've done it before a couple of times, so the package is
We
very
have.
nice. Thank you.
Yes, Commissioner Duffy, I have no question.
Okay, well, if there's nothing else, we'll declare the public record of this matter closed and we'll turn it over to the board for deliberation and decision.
I'll go ahead and make a motion that we grant the new license to True Food Kitchen, and looking for a second.
Commissioner Pilkins,
Duffy, a second.
Okay, second. All those in favor say aye.
Aye.
Commissioner Pilkins.
Okay, motion is carried. Congratulations and good luck all.
Thank you.
You.
All right, Mr. Dales, you want to take it over on our rule change?
Our next item on the agenda is the proposed rule change that is stated on the agenda. And I think we should note that the board has received public comment. Mr. Aronson, how many comments have you received from the public on this proposed rule?
Yes, we received 3 in opposition. They have all been received and reviewed by the board members.
Thank you. And the rule was properly advertised in local publications?
Correct. For 2 weeks and 2 different publications, plus it's been on our website for about 10 days.
As Mr. Aronson noted, we properly advertised and received comments on the rule, and the board commission members have all read the proposed or the comments on the proposed rule. So if we can just turn this over, Mr. Chairman, to deliberation, any discussion over the proposed rule, and then when you're ready, a motion.
Okay, I'll turn it over for discussion at this point. I will just basically say the rule is looking as what it says to any change in the Class D permitting offsite consumption of floor space devoted to retail is that it's accompanied by justification in addressing the criteria of the Maryland Code. So with that, I think it's prudent that we look at it that way, and I'll turn it over to the other commissioners for thought and comment.
Well, Commissioner Pilkins, I read the dissenting items and disagreed with them vehemently. This isn't something that we're doing frivolously. This is I see it as a serious need. I think that the rules, the previous rules, were extraordinarily broad, and they didn't give us any limits, and it's almost impossible to manage those licenses. I thought that the proposed rule was well written. It put some limits on things that I think are fair, and I think our folks did a really good job putting it together.
Thank you.
Commissioner Duffy, I concur. I think there is a need for the change of the rule, in particular with the floor space that was being utilized and the request that we were receiving in reference to converting floor space. So I think the rule was much needed. And I think and it's for the benefit of all licensees, and I don't feel that it's prejudiced in any way, form, or fashion. And I don't think that we have exceeded our authority as a liquor board and the commissioner to propose this rule and to implement this rule.
Okay.
And I did feel the opposition to the rule change in and of itself, and I do not concur with their comments and statements.
Okay. Any other thoughts, comments? This time, I'll make a motion that we adopt the rules and regulations that we're talking about. And looking for a second.
Commissioner Pilkins, second.
Second it is. All those in favor say aye.
Aye, Commissioner Pilkins.
Aye.
The motion is carried. Thank you.
Excellent. Thank you. Thank you.
And that, I think,
Very, very nice. Very nice.
yeah, finally, I think that concludes our meeting unless there are other comments or any discussion.
Except I'd say good job by everyone today. Thank you.
Excellent.
It's a nice, nice meeting. A lot of legal help, huh? Yeah.
Wow.
Superb.
That's why we now have 2 lawyers, right?
Yeah.
Okay, I'll motion to adjourn.
Commissioner Pilkins, make a motion to
Adjourn?
Oh,
Okay.
well, I second the motion.
Okay, I think all in favor say aye.
Aye.
Aye. Thank you.
Thank
Thanks,
you.
guys.
Okay.
Take care. Thanks, everyone.
Thank you.
Adios, everyone.
Thank you.
Adios.